here I was as a young, relatively young physician, 6 years out from my fellowship training, and I was asking myself, who do I turn to and what do I do and what are my next steps? Unfortunately, I didn't have an insurance company that's quite as good as the one that covers me now, and I learned an awful lot about professional liability litigation during my experience. So here's the next question. When confronted with a claim letter from a plaintiff's attorney, your first step should be to, 1, call or write the attorney and ask for more information, get out the chart and look for inculpatory evidence that may be harmful to your case. Inculpatory evidence would be information that's contained in the chart that you might consider to be damaging to your case. Contact your professional liability insurance carrier or review the demand letter with your partners. Well, I see that everyone's got the message. That's absolutely right. Contact your professional liability insurance. That is your best line of defense. There's no better place to turn, and in fact, it's essential that you do that in order to trigger coverage under your insurance policy. And it doesn't matter which carrier that you have your insurance with. It's essential that you get in touch with your insurance carrier and talk to the claims people. Now, the follow-up question is, when should you contact your professional liability carrier? Answer number 1, a letter or phone call from an attorney requesting money to settle the matter, a phone call from a patient requesting my money back, a letter from an attorney notifying you of a pending suit, or 4, all of the above. That's correct, all of the above. Remember that a request for money is considered a claim, and it needs to be reported. A claim can be defined as a written notice or demand for money or services. A potential claim, on the other hand, is an oral notice of an adverse outcome that you may have discovered or know about, some event that occurred that you're not comfortable with, and these are sometimes known as incidents. And it's very helpful for you to feel free to discuss these with the insurance company, but usually you're going to be referred to the risk management department to discuss these types of incidents, and you are going to be discussing it with a claims representative. The reason that insurance companies like to know about these incidents is because it gives them some idea of the potential claims that are going to arise. They actually have statistics that will say how many claims are going to rise out of so many incidents. So it's helpful for them, but it also certainly begins the process of sequestering information that may come in, or if they're contacted by a patient or by an attorney, they're already alerted to the fact, and their antennae are up and ready to respond on your behalf. So remember that even in incidents, it doesn't count against you, and it's important for you to contact your insurance carrier for any of these types of things. Also remember that the demand may come from a patient, a parent, a legal guardian, or an attorney representing the patient. So just because it doesn't come from an attorney is no reason not to get in touch with your carrier.